September 8th, 2015, Franklin Nolan, reading the 19th Congress First Senate calendar docket number 205, report number 95-227, amending public law 97-198, May 23rd, legislative day, May 28th, 1977. Ordered to be print, Mr. Ribicoff from the Committee of the Governmental Affairs, submitted by the following report to accompany S1063 as follows. The Committee on Governmental Affairs, to which referred the bill S1063, having considered the same report favorably, thereon the amendments and recommendations that the bill is amended do pass. On line 3, strike public law in quotes, public law 93-198 in quote, the substitute therefore in quotations, the District of Columbia Self-Government and Government Recognition Act in quote. On line 6, the word act should not be capitalized. Amend the title so as to read an act to amend the District of Columbia Self-Government and Governmental Reorganization Act. Purpose of bill. The purpose of the bill of S1063 is to allow the preceding revenue bonds which have been sold under the acts approved by the District of Columbia Council and Congress to be readmitted to entity for those benefits of bonds were issued without further legislative action. Okay, background and needs for legislation. The Home Rule Act for District of Columbia, Public Law 93-198, specifically authorizes that the council may issue revenue bonds, notes, and other obligations, including in parentheses, including refunding bonds, notes, and other obligations, in parentheses, the borrowed money to finance or assist in the financing of undertaking in the areas of housing, health facilities, transit, utilities facilities, recreational facilities, college and university facilities, and industrial and commercial development. Bottom of the page is 89-010. Second page. The section further provides that any and all bonds, note that the obligations shall be general obligations of the district and shall be a pledge of involvement of faith and credit or tax power of the district, shall not be constitute a debt of the district, and shall not constitute lending of the public credit for private undertakings. Under the provision of the House Rule Act, all expenditures of the district government from its treasury must, and prior approval for Congress, the District of Columbia, on behalf of the members of the consortium of the University of Washington, D.C., in disastrous authorization and insurance of revenue bonds which have their purpose in improvement of facilities of higher education in the District of Columbia. The bonds issued would be guaranteed by the institution of higher education which was receiving the benefit of the use of the funds. Okay, during the course of the revenue, the steps are required in order to successfully issue the market such bonds. Bonds counsel strongly advise that the district and elimination of the congressional approval of the transfer of the money of the benefiting college or university would improve the marketability of the bonds without any way reducing the authorization of local federal governments over the use of which such bonds are input. The District of Columbia government asks that the amendment contained in the legislation be applicable to all types of revenue bonds. The committee decided that that this might be too broad a delegation, and it was advisable to see that the delegation work prior to increasing its scope. Okay, the provisions of this is S1063. The bill would add the subsection to the section of the Home Act, authorization and insurance of revenue bond, to state that the payment made pursuant to act authorizing the issuance of revenue bonds, and that may be made without further authorization or approval. Okay, hearing and committee vote. Okay, the Subcommittee on Governmental Efficiency in District of Columbia held a hearing on S1063 on April 27, 1977. The Committee on Governmental Affairs anonymously ordered the bill to report on May 12, 1977. After discharging the committee from further consideration of the legislation, the District of Columbia and representatives of various colleges and universities testified in favor of the legislation. No one appeared or submitted a statement in the opposition to the legislation. Congressional Budget on Office Estimate and Comparison. No estimate and comparison of costs has been received by the committee from the Director of the Congressional Budget Office. The pursuant of the section is 403, and Congressional Budget and Impounding Control Acts of 1974. See the cost estimate below by this committee. Okay, under the cost, the enactment of the proposed legislation will involve no added cost to the government of District of Columbia government nor to the federal government. Inflationary impact. So the bill, if acted, will have no foreseeable inflationary impact or prices or costs in operation of the national economy. The Regulatory or Privacy Act, in accordance with the rules XXIV, there is a regulating or privacy and impacting caused by this legislation. Changes in this existing law made by the bill or as reported in compliance of subsection 4 ruling of XXIX of the standing rules of the Senate, change in existing law made by the bill as reported are shown as follows. Existence of law proposed to omit is enclosed by black brackets. New material is printed in italics. Existing law is in which no charges proposed is shown in Roman. Okay. The District of Columbia Self-Government and Governmental Reorganization Act. And this is Part D, District Budget and Financial Management. Subpart 3, Payment of Bonus and Notes. Okay, the revenue bonds and other obligation. Okay, this is under Section 490, subsection alpha. The council may, by act, issue revenue bonds, notes, or their obligation, including refunding bonds, notes, or other obligations to borrow money to finance or assist in the financing of undertaking in areas of health facilities, transit and utility facilities, recreational facility, college and university facilities, and industrial commercial development. Such bonds, notes, or other obligations shall be fully negotiable and payable to or as to both principal and interest solely from the secured solely by a pledge of revenues realized from the property, facilities, developments, and improvement of those facilities is undertaken by the issuance of such bonds, notes, or other obligations, including existing facilities to which such few facilities and improvements are related, which financing may be effected through loans and may directly or indirectly, including purchase of mortgages and case description in subsection Bravo of this section, note, and other securities to any public, quasi-public, or private corporation, partnership, association, person, or other entity. Subsection Beta, except in the case of housing, recreation, commercial, and industrial development, the property, facilities, and development and improvement being financed may be mortgaged and additional security bonds, notes, and other obligations, but in no event shall any property owned by a District of Columbia or the United States be mortgaged for or the purpose of this section. Okay? Pay note of that. Subsection Charlie. Any of such bonds, notes, or other obligations shall not be general obligations of the district and shall not be pledged of or involved in such faith, credit, or taxing power of the district shall not constitute the debt or district and shall not constitute lending of the public credit for private undertaking as contained in the section. It's under 602 alpha 2. Okay. Subsection delta. Any and all such bonds, notes, or other obligations shall be issued pursuant to an act of the council without necessity of committing the question of such issuance to the registered qualified electors of the district for appropriate or disapproval. Okay, subsection echo. Any such act may contain four provisions. 1. Briefly describe the purpose for which such bond, note, or other obligation to be issued. 2. Identifying the act authorizing such purpose. 3. Prescribing the form, terms, provisions, manners, or methods of issuing and selling, including negotiation as well as competitive bid sale, and time of issuance of such bonds, notes, or other obligations. And 4. Prescribing any and all other details with respect to any such bonds, notes, or other obligations and issuance and sales thereof. Okay, we'll move on to subsection Foxtrot. In quotation, payments and authorized are required to be made by pursuant of any act authorizing the issuance or receiving bonds, notes, or other obligations for college, university facilities under the section shall be made without further authorizations or approval, end quote. Okay. Sum it up. The act may authorize and empower the mayor to do any and all things necessary, proper, or expedient in connection with issuance and sales of such notes, bonds, or other obligations authorized to be issued under the provision of the section. The mayor. That's calendar note number 208. That's the 95th Congress, First Section, Senate. Report number 95-227. Docket 95/1 S. RPT 227. Legislation date May 19th, 1977. Amending Public Law 93-198. This is Franklin Nolan. You can contact me at frankienolan@gmail.com. Telephone number 775-203-6497. Have a good night. This is September 8th, 2015. Ciao.